So today we are going to focus on one decision, which is important, not because it touches upon the conduct obligations of the parties so much, but it touches upon another topic which is very important also in the last years, and it's about the jurisdiction of courts to decide front disputes, and especially to set the terms of global front global front terms. So this is a decision from the UK this time, which we're going to focus on today. And at the end, I will also very briefly give you an insight on a decision that came from Germany, which refers to a very specific question, and that's the question whether a party which is involved in a case which is about an SEP, whether it can get access to the court files of another case which involves the same patent, which however is a case which is led between different parties. So this is a very specific question, but it's something that we might encounter in our work. So it's good to have a brief impression of how a German court has answered this question. So let's start with the first case. It is a case where Nokia on the claimant side is involved, and Oppo and other companies which belong to the Oppo group are also involved on the defendant side. This is a decision of the Court of Appeal, which means that this is a second instance decision. It's, however, still a case where we have not entered into the merits of the dispute, but we are talking still about the jurisdiction. So let me give you here, as always, a brief background of this case. There was a license deal between Nokia and Oppo, which was a 3 years agreement, and which would expire in the end of June 2021. So before that, the parties were in discussions about a new license agreement, but these discussions did not end up in a license agreement, at least not until the end of the previous agreement, which was in force. So the agreement was expired on the 30th of June, and already the next day, on the 1st of July 2021, Nokia filed an action against Oppo in the UK. There it was about the infringement of several UK patents, and as part of the relief, Nokia sought there the determination of the terms of a global license for its portfolio. So this was the first action that was filed in this case. There were further actions filed in different jurisdictions all around the world. There were some cases also in Germany, as we're going to see in a moment. And apart from that, there are also cases filed in China. This time there were cases which Oppo filed in China. So some weeks after the action was filed in the UK by Nokia, Oppo filed an action against Nokia in Chongqing in China. And there were two different topics which the court needed to decide upon. One was the front commitment, and the other one, which was more important and more interesting for our case here, were the terms of a global license for Nokia's portfolio. So Oppo requested from the court in Chongqing in China to also determine the terms of a global license for Nokia's portfolio. Now Nokia contested the jurisdiction of the Chinese court to do so, and the same did Oppo with respect to the proceedings in the UK. So in the beginning of August 2021, Oppo filed a motion to stay the UK proceedings, asking the court there to stop basically the trial until the court in China has rendered its decision. And it also contested that the courts in the UK have jurisdiction to decide the case. So the first decision, which was delivered by the courts which were involved here regarding the jurisdiction, issue was delivered by the High Court of Justice in England, and this was in the beginning of November 2021. With this decision, the High Court confirmed the jurisdiction of the English courts to move on with the case, and it also dismissed Oppo's motion to stay the UK proceeding. So the court said the UK courts are capable of deciding the case and will not wait for the case to be decided in China first. Oppo appealed this decision. So this case moved on to the Court of Appeal, again focusing on the jurisdictional issue. Then a month later, almost, the Chongqing Court in China also delivered a judgment regarding its jurisdiction, and it also confirmed the jurisdiction of the Chinese courts to decide the case, especially the jurisdiction to set the terms of a global license. So this was the second decision confirming basically jurisdiction. This time this decision was appealed by Nokia. The appeals in these proceedings, in both proceedings, have been or also decided today. The first decision was from England. It's the decision we're going to take a closer look in a moment. In the 11th of July 2022, the Court of Appeal rendered this decision and basically confirmed the decision of first instance. It confirmed that the courts in England have jurisdiction to decide the case brought by Nokia, and again, it also did not stay the proceedings in the UK pending the Chinese parallel case. What has happened after this decision is interesting. There had been, in the meantime, in August 2022, there were decisions from Germany on the merits of the case. So the German courts, in contrast to the Chinese and the UK courts, decided the case on the merits and granted injunctions in favor of Nokia, since they found that Oppo has been infringing German patents. These injunctions were granted in August. And then in the beginning of September, there was also the appeal decision from the Chinese side. There, the Supreme Court, People's Court in China also confirmed the jurisdiction of the Chongqing Court to make a global rate determination here in the present case. So this is more or less where we stand here in the English and the Chinese proceedings. The jurisdictional issues seem to be resolved now, so the case will most likely proceed now with the merits. And in Germany, we had already 2 injunctions that were granted in August 2022 in these proceedings. Now, if we look at the reasoning of the court here, I think to understand it a little bit better, it's very helpful to take a look at the status here. So how is the status regarding these questions? How is the law in the United Kingdom in this respect? And to have a good impression of that, we should look at back at the decision of the UK Supreme Court in the Conversant versus Huawei case. So this is the case which has basically set the standard in the UK in this respect so far. What did the Supreme Court decide there? The court said basically that in such cases where you have claims for the infringement of a UK patent asserted by the patent holder, the English courts will have jurisdiction, of course, to take up the case and also to set up the terms for a global license. This is, however, part of the relief which the patent holder can receive if there is a finding of infringement. The English courts in this case would grant an injunction, a front injunction, meaning that they would give the implementer the option to take a license based on the terms which the court will determine as front, and this would be a global license. And if the implementer would not do that, then he would have to face an injunction in the UK. And the Supreme Court confirmed that the courts in England have the jurisdiction to do that. So this is basically the status quo before this decision here. And as we're going to see in a minute, the Court of Appeal followed more or less this decision. So it did not deviate from the Supreme Court's decision and followed the same principles. What is interesting about this decision here, the specific decision, is that it contains a part in the beginning of the reasoning of the court where the court makes some general remarks or observations of what is the general background of SEP disputes. And I think this is very interesting to take a closer look at, because this has influenced also the decision of the court in the merits on the one or the other aspect. So here, the court, when it comes to front disputes, it started basically by looking at standardization in general. So what is standardization and what are the benefits of standardization for technological progress? For example, the court found that standards have played a significant role in this respect. And then it started looking more specifically at the ETSI IPR policy. And reason there, what is the goal of the ETSI IPR policy? What does it intend to do? And here, in the eyes of the court, a goal of the ETSI IPR policy is to strike a balance between the interests of the patent holders and the implementers. And this happens, among other things, also in the public interest. So this is what the court generally sees is the mission of the ETSI IPR policy. And then looking more specifically at the front undertaking of the patent holder under the ETSI IPR policy, the court here followed the view of the Supreme Court and confirmed that the front undertaking is a global undertaking, meaning that it refers to global standards and global portfolios, and it's also to global products. So it has this global character. And the court pointed out that at least to its understanding, the front undertaking is designed to prevent both hold up and hold out. The court called hold up and hold out the two evils of front cases. That was interesting. Why? How can the front undertaking do that? The court said preventing hold up. The front undertaking can achieve that by basically giving the implementer a defense against claims for injunctive relief, if of course the requirements are met. And on the other hand, the court said that a holdout is prevented by allowing for injunctive relief in case, of course, the respective requirements and duties have been fulfilled. So this is how the front undertaking is designed to prevent both hold up and holdout. And the court added here, and I think this is the interesting link to the litigation part of FRAND, that in order for this goal to be served, so to have an avoidance of hold up and hold out, the court reasoned that you need to have a well-functioning dispute resolution system. So to fulfill this this promise, basically, of the front undertaking, a functioning system to resolve disputes between patent holders and implementers must be at place. And the court asked itself, is this system available? Do we have a well-functioning dispute resolution system? And the court seems here to argue that the most well-functioning or the most adequate dispute resolution system here would be a international procedure or supranational procedure, which is, however, not available for the moment. So you don't have an international tribunal or a supranational tribunal which would decide these cases. The closest thing to an international solution that you have for the moment is arbitration. which the court seems to favor here. But of course, arbitration would only work if parties agreed to use arbitration. So basically, if you don't have an agreement here, you end up the only possible option there is the national court system. And looking at the specific characteristics of the front cases, the court said here that in its view, national courts cannot solve all the problems that are inherent in the present system of resolving front-end SCP disputes. So the court took the view here that national court systems and national courts have certain limitations when it comes to resolving this type of disputes. And the first limitation is, of course, that a national court can decide only about the validity and the infringement of national patents. So if the patent holder needs to assert or enforce patents globally in different jurisdictions, then he needs to have a country-by-country enforcement. And in the eyes of the court, this is not very efficient. On the contrary, the court saw here that a country-by-country enforcement of SEPs is placing a significant burden on the patentees and is also a type of disadvantage for the patent holders. The court said here the implementer has the possibility to engage in a war of attrition, basically as allowing, basically trying to starve off the patent holder of licensing income. So this would especially happen if the patent holder is forced to engage in different proceedings in different jurisdictions and trying to enforce patents nationally over or around the world. So this can be, of course, a problem with the cost, the time spent, etc. here. So the court saw here a benefit which implementers might use. And a potential solution to level things up again would be to have a global determination by a single court. And this is something which the court noted that more and more courts around the world are trying to do, and at least declare themselves competent to do. However, the court said here you have also to take into account that there are some limitations on how effective this global front determination by a single court can be. And it mentioned here some examples. One of them is that there is always the possibility for an implementer, let's say, to escape a global front determination by a single court if, for example, it chooses to exit the specific market and then prevent the court in this jurisdiction to determine the terms of a global license. So basically, we have seen this scenario in the UK in some cases where the implementer would choose to accept an injunction and basically stop sales in the UK, and on the and for that the proceedings would be stopped, so the court would not determine the rates of a global front license. So this is one way out for avoiding a global front determination by a single court. But even if this does not happen and courts take up the case and have the possibility to decide, then of course there are some problems which arise when several national courts assume jurisdiction. And here are some pretty evident problems which the court mentioned. So one problem is, of course, the risk of inconsistent decisions, that the terms set by the different courts are different about the same global portfolio. Of course, the costs of having to pay for proceedings in different jurisdictions or around the world. Then the court said if you would accept that the first court seized with a case would be the one also determining global front rates, then what this can generate is a race of the parties to the most favorable forum. So either the patent holder or the implementer would try to establish proceedings in their favorable jurisdiction in order to prevent other courts from also taking up the same task. And as another problem associated with with several national courts assuming jurisdiction, the court also identified anti-suit injunctions and the anti-suit injunctions. So these are some thoughts of the court regarding where are specific limits of national courts when it comes to resolving front and SCP disputes. And as we're going to see in a moment, these observations of the court here have been also mirrored in some aspects of the decision of the more detailed analysis of the court.